Hi, I'm Amber Hom, your friend in real estate. Today we're going to touch on wills and trusts. It may sound a little boring, but if you're already familiar with these staples of real estate planning, trust me, you will learn something. See what I did there?
Realm Real Estate, your guide to everything real estate in Concord and the East Bay. Connect, inspire, guide.
When it comes to protecting your loved ones, having both a will and a trust is essential, especially if you own real estate and or have children. The difference between a will and a trust is when they kick into action. A will lays out your wishes for after you die. A living revocable trust, however, becomes effective immediately. While you are alive, you can be in charge of your trust, and if you become incapacitated or die, the person you appoint as the successor trustee can easily step in and handle your affairs exactly as you have laid out in the document. It is my strong opinion that you should have both a will and a living revocable trust. So why would you need a trust? There are many types of trusts, about 15 in all. For the vast majority of folks, a living revocable trust is the best option. A living trust can do wonders for your estate. It can help you avoid probate fees and court costs, maximize your tax exemptions, who doesn't like tax exemptions, provide your children with property tax benefits, and much more. It also allows you to determine who will receive distributions in the manner you want, all while keeping it personal and out of the court system. I don't know many people who say you should try to avoid any of these things. Here's what we're going to do. We're going to break this down word by word. Living. A living trust is effective during your lifetime. Revocable. Everything you state in the trust can be changed at any time, meaning you can revoke your directives. With this type of trust, you're less likely to second guess yourself or have anxiety signing those papers. With a revocable trust, you can relax. This is a legal document that you can change as your life changes. Trust. Once you create a trust, you can move the ownership of key assets, such as a home and or other property, into the trust and appoint yourself as the trustee, meaning you call the shots on how to use and manage those assets while you're still alive. You also appoint someone to be your successor trustee. If you become incapacitated, the successor trustee can step in easily and manage your affairs with the instructions that you set in place. Or when you die, the successor trustee takes over without the need to get any court approval. Again, staying out of that pesky court. It's important to understand if you only have a will, when you die, your family may have to go through a lengthy court process to fight for the right to follow what you laid out in your will. This is called probate. In addition to being time-consuming and costly, you likely will need to hire a lawyer. It's also public. So when you die with only a will, that document must be filed with the court and can be accessed by anyone. So your business is all out there. Smaller estates may be able to avoid probate if the deceased only had a will. But in most states, the cutoff for what amount qualifies for a simplified probate is quite low. Look, you didn't check in with the courts when you accumulated your assets over your lifetime. So why should your family have to go through the courts to receive what you've left for them? The surest way to avoid probate is to have a trust. A living, revocable trust does not need court approval. Everything stays private, and your successor trustee can take over its management immediately upon your death. Why you need a will. As important as a trust is, you'll also want to have a will. While your big ticket assets such as your home should be owned by your trust, you likely have other smaller keepsakes like a china collection, your grandmother's watch, your Beanie Baby collection, I'm not judging you, that you want to give to a specific person.
I love them and I'm obsessed.
A will is where you'll spell this out. A will is also where you can write down your funeral wishes. If you have young children, you must have a will. A will is where you appoint a guardian for minor children. I realize thinking about this can be quite upsetting, but let's talk about something even more upsetting. If you die without a will that establishes your children's guardians, decisions about the care of your kids are going to fall to the court system. That's what happens when parents die without a legal guardian ready to step in. Sure, a sibling or cousin or other friend might end up as the guardian, but only after a draining court process and potentially ongoing court oversight. You love your family more than anything, right? Having both a will and a trust is a powerful way to show your love for them. It will save your family time and money, not to mention the heartache of squabbles if you were to die and not leave clear instructions on who is to get what. If you don't currently have a will or a living trust, I hope the information in this short video makes you take stock of your personal situation and take action in starting this process for yourself. If you have any questions or suggestions for further topics, please let us know in the comments below. And be sure to hit that like button and forward to a friend or family member who may benefit from this information. I'm Amber Hom, your friend in real estate, and I'll see you next time.
Realm Real Estate, your guide to everything real estate in Concord and the East Bay. Connect, inspire, guide.